So we'll be starting momentarily. Joining online. I see Nairobi is checked in Geneva, I think. Can we do a quick mic check, Su Young?
Good morning, Carl and Lydia. Can you hear me?
Sorry, can you try again, please?
Okay. Good morning. Can you hear me?
That's good.
Excellent.
And Patricia?
Good afternoon. Can you hear me?
Yes.
Good, yes, that coming through clearly. Thank you. Okay.
All right. Good afternoon, everybody, or hello, whatever time it may be where you're located. Welcome to the Environmental Law Institute's new series on the environmental rule of law. Today's event is kicking off our series by discussing the new report that the UN has published on the environmental rule of law. We're so excited to see all of you here in the room and online. So for our in-person folks, there are also a bunch of people watching live via webinar, but all future installments of this series will be taking place only via Zoom webinar. This is our only hybrid one. So we're so excited to see everyone, and all future installments of the series will be on the first Monday of each month through July. So we will put the link in the chat. And if you're here in person, we just encourage you to go to eli.org to find the rest of the series. So we can now get started with today's event. For our virtual audience, please put any questions that you have in the Q&A box on Zoom. You can put the questions in as soon as you think of them. There's no need to wait until the end. For our in-person audience, though, if you could hold your questions until the end, me and my colleague Sarah will be coming around with mics near the end of the program. Should you need anything, please feel free to find us in the back of the room. And now I will go ahead and turn things over to Carl, our moderator, who's a senior attorney at ELI. Thank you so much, everyone.
Thank you, Madison, and thank you all for joining us both here at ELI and online. It's really exciting to be launching this. This is the second global report on the environmental rule of law, and I think it's safe to say that both have been labors of love, both on the labor side and on the love side. And we will have a series of presentations followed by a discussion. We'll start off with Patricia Kamara-Mbote, who is Director of the Law Division at the UN Environment Program. And she'll talk about what is environmental rule of law, why is it important. And then Su-Young Wang is a legal officer also with UNEP. We'll be talking about the methodology. This was different from the first report, and I think it's interesting to see, the differences in how we approached the first and second reports. And then I'll give an overview of the findings of the core chapters, and that's following essentially the methodology of and the framing of environmental rule of law. And then Lydia will talk about the thematic cross-cutting issues, because within each of these, we're seeing developments that are shaping, for better and for worse, environmental rule of law. And it's interesting to kind of take a step back and look, what are these key drivers of environmental rule of law? And then we'll open it up for Q&A. So Patricia, the floor is yours.
Thanks, Carl. Good evening again, and good afternoon, good morning, friends and colleagues. I am really pleased to be here with you today as we launch the second Environmental Rule of Law report, subtitled Tracking Progress and Charting Future Directions. I'd like to take this opportunity to thank everyone who supported the development of the report, and in particular, the two lead drafters who are with us today, Lydia Slobodan and Carl Brook. Let me start by giving some background information on environmental rule of law, as Carl said. And I think we start with where does this concept of environmental rule of law find its basis in internationally negotiated documents. UNEP's mandate to strengthen environmental rule of law is traceable to 3 important decisions. The Governing Council Decision 27/9 of 2013, the United Nations Environment Assembly UNEA Resolution 4/20 of 2019, and the Political Declaration of the Special Session of the United Nations Environment Assembly celebrating UNEP 50 in 2022. What then is the environmental rule of law is the second issue I'd like to address. The idea of the environmental rule of law is still growing and changing, and this is not surprising because of the dynamism of the environmental challenges that we face. Basically, it means using the principles of the rule of law to protect the environment. And as we all know, traditional rule of law puts brakes on power excesses and abuse of power. Environmental rule of law is no different. It has strong resonance with the United Nations Secretary General's Our Common Agenda's call for a renewed social contract. In breaking down environmental rule of law, UNEP has pointed out 7 important parts. The first one is that we need environmental laws that are fair, easy to understand, and possible to follow. The second one is that everyone should have access to information about the environment, be able to take part in decisions, and have the right to seek justice. Third, people and institutions in charge of environmental decisions should be accountable and honest, so the public follows the rules and the environment is protected well. Fourth, there should be clear directions and cooperation between different parts of the government that handle environmental issues to make sure that things are done well and that there is no overlap. 5, when there are disagreements, decisions made should be fair, quick, and build trust in the public about the rules and laws for the environment. 6th, we must recognize and protect rights like human and constitutional rights because they help make sure the environment is safe. And lastly, there should be clear and specific guidance on how to understand and follow environmental laws, because this makes it easier for everyone to follow the rules and protect the environment. Why is environmental rule of law important is my next issue. Strong environmental laws and institutions are essential to achieving environmental goals and developing effective responses to pressing environmental crises. Laws provide the requirements, standards, procedures, and rights needed to achieve environmental objectives. Strong institutions are necessary to give force to those environmental laws. In addition to environmental benefits, environmental rule of law provides economic and social benefits. By improving the protection of the natural environment, environmental rule of law protects public health and economically valuable natural resources. By increasing transparency and reducing corruption, environmental rule of law can also attract investment, support sustainable economic growth, and ensure that resulting benefits to nature are fairly shared. Without the environmental rule of law, good governance beyond the environment sector is also undermined. Indeed, consistent, fair, and effective implementation of environmental law strengthens perceived legitimacy of government action and builds public confidence in institutions. Despite a global increase in national environmental laws and institutions over the past 50 years, implementation and enforcement have lagged behind other sectors. This has led to the mounting triple planetary crisis of pollution, biodiversity loss, and climate change. And this is why the environmental rule of law is very important. We must focus on the environmental rule of law to bridge the implementation gap and to respond to the extreme urgency and dire consequences of global environmental problems. So what are the objectives of this second report? This report aims to support countries to strengthen the environmental rule of law. It seeks to support countries to understand the status of and trends in environmental rule of law globally. The hope is that countries will be nudged or will be encouraged to improve indices for the environmental rule of law. My fifth message is what is different in this second report, having looked at the objective. The speakers after me will introduce high-level findings from each chapter and findings from cross-cutting themes. However, allow me to highlight two new approaches we have adopted in this second report. The first one is that building on the first global report, this report expands to provide a comprehensive, data-informed assessment of global trends, gaps, and opportunities related to environmental rule of law. My colleague Su Yang will provide a more detailed introduction to these indicators and their analysis. Secondly, the report provides a range of good practices integrated into each chapter. These good practices show what promotion and implementation of environmental rule of law looks like in reality. With these case studies, we aim to deepen understanding of environmental rule of law and inspire state actors and other stakeholders to replicate these practices whenever possible. In conclusion, colleagues and friends, let me reiterate that we face a big problem, the planetary crisis. It is serious. We need to act. The sixth session of the United Nations Environment Assembly that was concluded just last week showed us the power of multilateralism. It showed us that when countries come together to strengthen environmental action, good things result. The environmental rule of law can turn our common aspirations into realities. I hope that this second report and our discussions will help make the world cleaner and better for all of us. Let us work together to create a sustainable environment that benefits everyone. Thank you.
Thank you, Patricia. We are grateful for your leadership in this space. I'd like to turn the floor over to Su Yung at this point, and Su Yung is going to talk about how we got here.
Thank you, Carl. Just wondering, can I just quickly check? Can I share the screen from my side, the slides from my side? Because I made a bit of changes. Apologies. Carl, sorry, could you just tell me if you can see the slides from showing from my side? Okay, great, thank you.
Yes, I can.
Thank you, Patricia. So I only see Patricia and Carl and Lydia on the screen. So thanks so much, Patricia and Carl, and also ELI for organizing this meeting, and also Patricia for talking about the whole importance of environmental rule of law, and Carl asking how we got here. So I wanted to actually just pretty much focus on what Patricia mentioned about how, the two new approaches. So methodology-wise, I think one big methodology that we employed at this second report is really having objective environmental law indicators that can track how we're doing. So Also, first to start with that, what do we know? Like we know we are lagging behind, but how much do we know about what is lagging and what is the gap and what is the area that we need to improve? So this is the whole idea behind why we came up with this developing legal indicators and also the collection of data and also analysis of it. And before I get really started, I wanted to acknowledge how this this whole work on the indicators was a result of a partnership with many international and experts and the team of experts working at the country level and also at the global level. And so I wanted to especially thank Susan Kapp and Sam Bookman from SPAN Center and also Michelle King from White and Case. They did tremendous work of being able to collect all the data and also help us analyze and then integrate into this report. So I wanted to make sure that they're acknowledging this work. So, and what is the background of like why we are doing this? Like why did we do this report and this indicators is first UNEP published the first environmental rule of law in 2019. And one of the recommendations, one of the future work that we need to do as next steps is to strengthen environmental rule of law by conducting regular assessments to understand trends and identify challenges, share learning, and also capture public attention on this. So this is one way to do it was to develop a set of indicators that is consistent and that can also track progress nationally and globally and over time. So this is a follow-up to what we, the indicators work that we've done, and the second report was a follow-up to our recommendation and the next steps recommended in the first report. And the goals of this indicators work is to build a global snapshot of environmental rule of law. So Carl and Lydia have done an amazing work of having four substantive chapters and also having a cross-cutting issues on environmental rule of law analyzed. But what kind of other pictures can we give? It was like because, and then the answer was indicators like on how are we doing in terms of law implementation, or how we're doing it during COVID in terms of the law, and also identify the most prevalent aspects of environmental rule of law and track progress over time. So this is going to be, we're not going to let this as a one-time of thing. So as we will be actually continue collecting data and also continue improving the data, improving the indicators, because as we are doing it, we're also learning about legal indicators, and with there's a lot of developments and academic work going on in this area, and also to identify gaps in environmental rule of law. As I mentioned in the beginning, that we know we are lagging behind, but what is it like that we are lagging behind? And this will eventually, ultimate goal is to help implement environmental rule of law. So, and the process, how did we get to this develop 22 key indicators and the 22 questions? Is we structured these questions for each chapter. So laws and institutions, civic engagement, rights and justice. And we developed key 22 indicators that can actually capture what we're talking about rights, about civic engagement and justice. And the answers were in binary form. So the answer was yes or no. And the reason behind it is because, one, if we go to subjective terms, what do you think about it? Or answer it in the degree, that makes analysis a bit more difficult. But also we wanted to have more snapshot and objective data in a simpler form to start with. So we had a binary format. And so we started with a collection, development of questionnaires, and then we started with a collection of data and the first review and the second review, because we had to go through each questionnaire and also to see how the data collection was done, whether it can be answered yes or no, because sometimes there was a judgment. So we had to go through all these questions one by one, and then after it was done, we integrated into the checklist with the And today I just want to introduce four indicators from each report. just to give you an idea about what we have done, but I will not go into the details due to the time constraints. But first, I wanted to show you from the laws and institutions chapter. One question about laws was about related to COVID, because COVID was one of the biggest environmental factor that happened in the past few years, and during while we are preparing for this report. So one question was whether COVID-19 weakened the environmental protection or whether it strengthened. So this is a question that we wanted to solve. What is the impact of COVID in environmental rule of law? And this was quite interesting to see. Actually, there are a lot of so some countries and some the regions, they have reported they weakened the environmental protection. For instance, that they have skipped the public consultation process because of COVID. But some other the other question, the answers to the other question about strengthened environmental protection, that was also very interesting. Some countries and the regions, they strengthened on the contrary. So they strengthened their waste policy, and also the medical waste. And then some other countries, they had both the mixed results. So within one country, one aspect they strengthened it, and one aspect they also weakened it. And the other indicator that I wanted to introduce is on institutions. So it's the question about specialized prosecutors. How many countries has specialized prosecutors? As you can see, the importance of it in the institutions. Whether they so prosecutors, were they equipped and have the capacity to prosecute environmental cases, and also the mandates, explicit mandates on environmental issues, such as like police or customs. Do they have explicit mandate to address environmental issues? So those are the two questions I ask because we thought that will actually tell us about how strong the institution is to implement environmental law or existing law, environmental law. So as you will see, there are you will see like some countries and some regions, they actually have quite a lot of over 30 countries in Asia Pacific. They actually have a explicit mandate for police or the customs to work on environmental issues exclusively. And some other countries also have many countries actually have specialized prosecutors in their country to work on environmental issues. And third is civic engagement. We wanted to, so one of the key things for key issues for civic engagement and public participation and other issues that was for us, it was environmental defenders, because as many of you know, that 4 defenders per week they are murdered. And this is based on a very limited data, because data access is very challenging, especially on environmental human rights defenders. But our question was about whether the country has a law that explicitly protects environmental defenders. So we wanted to find out whether it's why environmental defenders are killed or harassed or intimidated. Is that because lack of law, or is it because of lack of implementation? So the question was, we were trying to identify where the problem is. This doesn't tell you the whole picture, but this is one of the things that we can tell. We can draw where the gaps are. So surprisingly, 60% of the countries in the Latin American Caribbean states, they do have laws that explicitly protects environmental defenders. But that's also the reason, as we know, that there is some kind of a dangerous region for environmental defenders to exercise their rights. So if you see like the regional gaps between the law and the data, and also some other countries, some other regions, they don't have a explicit law on environmental defenders, but they are doing, they may be doing better than other countries, but they also, environmental defenders have different levels of intimidation. So some regions, they have slap suits, some regions have physical violence and murders and intimidations. So this is one of the key indicators that we employed for the civic engagement. And another chapter on rights, that we had an indicator on the data on the right to healthy environment. So this is slightly outdated because a lot has happened in the last 1 or 2 years. So since this one is based on the data about a year and a half ago, and that this shows that about 80% of the UN member states, they recognize the right to healthy environment, and the constitutional legislation or other by becoming a party to international agreements. But since this when at this time when we did this data studies, about 158 countries were recognizing it. But since then, that's really good news. Canada adopted the Environmental Act that recognizes the right to healthy environment, and 2 other countries in the Latin American Caribbean regions, they became party to Paris Agreement. So now we have over 160 countries recognizing the rights. We thought this is a good indicator to the legal indicator that shows how the right to healthy environment is being recognized in globally and also regionally. And lastly, is the justice chapter. We had indicated an open standing, like because to see like is this how open standing can reduce the barrier for people to access justice. And as you can see, there are countries or regions they have open standing allowed, and some others they do not allow it. And the positive thing about the open standing at the regional level is also the Escazú Agreement at the Latin American Caribbean regions. They have an explicit clause to allow open standing. So it's this doesn't tell you everything about open standing or about justice, but as we move forward, we plan to, as I mentioned in the beginning, we plan to update and also track this data over time, which will be able to actually tell us a lot more about what is the gap and how are we doing and what is the area that we can improve. So as for next steps, we hope to continue working on this and also like with everybody who's involved and also many other stakeholders. And to also not two separate indicators in one side, but contextualize this data set to different contexts in the environment development. So I'll stop here, and thank you for listening to me, and I'm happy to answer questions later.
Thank you, Soo-Yung. And next, I'll give a summary of the core chapters of the report, and then Lydia will take a step back to highlight the cross-cutting issues. So there were 4 central chapters that tracked the categories of indicators that Soo-Yung identified, plus a 5th chapter on conclusions and recommendations. For the 4 central chapters, they followed a standard approach. Sorry, is there feedback? There's a little feedback. But there was an introduction, and this was an abbreviated version of what one would find in the first report. And this is where it gets interesting. In the first report, we laid out what is environmental rule of law. And for each of these issues, for laws and institutions, civic engagement, rights, we kind of talked about what are we talking about here? Why is it important? How does it work generally? And then we dive into the material. And so the first report has all that material. We're not assuming that the reader of the second report has read the first report. And so there's a brief introduction. And then there's a kind of a survey of the global status. Where do things stand right now? And it's just been a couple of years since the last one. So, globally, the status, there are some changes, but then looking at the trends, this is where life gets most interesting. It's like, where is there action? Why is that happening? And so I'll highlight those each in turn. And then for the conclusions and recommendations section, we highlighted what are the key findings across the 4 chapters, recommendations, and then we also gave a nod to where we thought further research was warranted. So on laws and institutions, in terms of the status, the first 3 points were things that Patricia noted, the triple planetary crises. And we see a lot of progress in each of these 3, some more general, some more specific. Climate change, we saw a growing number of provisions in constitutions that addressed climate change, and a rapid expansion of national laws and regulations on climate change, both mitigation and adaptation related, and a number of subnational. We weren't doing a scientific assessment of subnational, but there was a lot that was coming up, especially where the national wasn't, where a government wasn't necessarily doing work nationally, that a lot often the subnational units were acting. On pollution, I think the place where we saw the most development was around plastics, including the extended polluter responsibility. Approximately 127 countries have adopted legislation to regulate plastic pollution, with more than 90 countries imposing bans on single-use plastic products. In biodiversity, because of COVID, there is a lot of interest in illegal wildlife trade, and so and the links between illegal wildlife trade and zoonotic diseases. And with that, we also saw an increasing criminalization of violations of biodiversity law. We also saw a growth in adaptive management, and this is a very different way of thinking about environmental law. There's kind of a traditional command and control: do this, don't do that, very clear. When things are in motion, though, you don't necessarily know what's necessary. And adaptive management provides a model by which you take actions and then you see what's happening, and then you adjust, and you see what's happening, and you adjust. You manage the situation adaptively. And so a growing number of laws are incorporating adaptive management. And we also see a growing recognition and analysis of areas protected by Indigenous peoples and local communities. On the institution side, I think that Soo-Yung covered a certain amount of this. We see a growing number of independent environmental protection institutions, explicit mandates for prosecutors and law enforcement to focus on environmental issues. We also saw capacity and resources limitations that set back environmental rule of law due to COVID. We also had, there are a couple of other little things in there, but I mentioned them because they're interesting for certain people. We've seen a number of countries, both legislatively and traditionally, recognize the non-regression principle. We see a growing kind of refinement and reiteration of framework environmental laws. And we see a growing attention to laws of public administration, particularly around transparency and accountability. In terms of the trends as they relate to laws and institutions, impacts of COVID-19 on environmental laws and institutions, and Soo-Yung had highlighted some of those trends. We also see a growth of technology in environmental enforcement. And some of these are familiar, using sensors to detect emissions, things like that. But we're now seeing artificial intelligence, and Brazil using artificial intelligence to prepare critical criminal complaints. The use of machine learning, satellite monitoring systems, and Earth observation. Even as we see a growth in national laws, we also see at the same time increasing pluralism and decentralization. Looking at, not only do you have national laws, but what are cities and subnational governments doing, local communities and co-management, especially in biodiversity areas. indigenous peoples and customary law being recognized in parallel to the statutory laws, development of private conservation frameworks and allowing for that, and the importance of women in the development and implementation of environmental laws and institutions. We're also seeing a growth in integration and coordination. And environmental law historically has been very segmented. There's the water law, the land law, the air law, and even in countries that have a framework environmental law, it still gets very segmented. But we're seeing that through different contexts, through integrated land management, water, energy, food nexus, people are coming to look at how do these different sectors relate and how do we integrate the laws. And then we also see a growing criminalization of environmental offenses. On civic engagement, again, I think Sue Young's covered a certain amount of this, but I'll note that we have seen a growing interest in this, especially driven by the attacks on environmental defenders. And the question being, what can we do about it? So I think that's one of the things that there's been a lot of attention to. Another is the role of women in environmental advocacy. There have been a couple of regional developments. And to be clear, the global report focuses on what's happening in nations, particularly at the national level. But these regional developments are important in shaping national laws, institutions, and practices. And so particularly for the Aarhus Convention, which is in the European Economic Commission for Europe context, operationalizing the rapid response mechanism for defenders, and the adoption and entry into force of the Escazú Agreement in the Americas, which clearly addresses for the first time in an international agreement environmental defenders. And so on the civic engagement side, we saw a number of challenges related to the COVID-19 pandemic, especially essentially the closing of government, that there weren't public hearings, there weren't opportunities, the traditional opportunities for the public to engage. At the same time, we saw the development of virtual public engagement, for what it's worth. And you could say it's not the same, this is only partial credit, but the fact is that it is enabling more people to participate who couldn't. And one of the things that we found along the way was that a number of women who might have otherwise had responsibilities at home and they couldn't actually go out to meetings, they could participate virtually. So there's, we need to look at this in a more nuanced way. But we're also seeing, so we see a lot of digital platforms for participation and information sharing. Citizen science is growing. The question of what do you do with citizen science if it hasn't been QA/QC'd? And questions about the digital divide. Who has access to virtual engagement? We also saw growing activism connecting racial, social, and environmental justice, not just in the US, in a number of countries. And that is driving more inclusive participation. On the rights side, we see recognition of the right to a healthy environment, much of it driven by the UN General Assembly resolution, both leading up to the resolution and since then. We're also seeing growth in recognition of the human right to water and other rights. And I think that Patricia I want to be very clear here. Our analysis of rights included human rights, constitutional rights, and rights guaranteed by statutes. But it's the rights-based approach, in part because there are often very vigorous debates over, is such and such a right a human right or not? And so, but it is guaranteed through multiple mechanisms, multiple instruments. So we're focusing more on rights in the context of rights-based approaches, however the rights may be found. we also saw the integration of environmental considerations in human rights mechanisms, including national human rights institutions. And so COVID-19 highlighted the links between environmental rule of law and a variety of rights. Populations that have been historically marginalized, particularly indigenous peoples, were disproportionately impacted by COVID-19. And this generated the human rights engagement in this space. I mentioned about the integration of environmental related rights and recognizing that this often cuts across sectors and institutions. The recognition of a right to a healthy environment, this already was in 100 constitutions or more, but the UN General Assembly resolution really pushed forward the discussion. And then not only do you have the rights on paper, but these rights are increasingly being used in litigation. Rights of future generations, right to a healthy environment, especially around climate change. And then also kind of not at this stage of dozens of countries, or let alone 100 countries, but we are seeing growing recognition of the rights of nature. And it's still small, but there's clear growth globally. In terms of the specialized environmental courts and tribunals, these continue to be used a lot and continue to be developed. Open standing, we see open standing in environmental cases, and also separate additional recognition of NGOs that are environmental NGOs to pursue. So it's not necessarily open standing, but it's broader standing. One thing that we wanted to highlight in this was the risks associated with civic engagement, that in a lot of countries, 128 countries, there's the loser pays principle. US is, basically, each party bears their own costs unless there's some overriding reason not to. But in most countries around the world, if you bring a case and you lose for whatever reason, there generally is a risk that you have to pay for the other side's attorney's fees and costs. This is a huge risk and huge impediment. We do see a number of jurisdictions that allow the loser pays principle to be overridden in particular cases, such as in public interest environmental litigation. But that's not the default. And so this is a big risk for a lot of advocates in a lot of countries. And on a more positive note, we see the growing number of judicial institutions, the judicial training institutions, at least 39 countries that have included environmental law in their judicial training activities. I'll note that Jay Pendergrass has been doing judicial training on the environment with, with Kathy Stein and others since the late 80s. But it's still, still almost 40 countries out of 190. So there's still work to be done. Nice to know there's job security. In terms of trends on justice, again, COVID-19 played a role in making in-person proceedings problematic. We have seen a lot of judicial action on climate change, largely because people are bringing a lot of cases. And part of this is because the executive branch and the legislature are not adopting legislation that people feel is necessary to protect rights of future generations, to protect the right to a healthy environment. And so they're turning to the courts. We're seeing a diversification of remedies beyond the traditional fines and imprisonment, to include environmental liability. Again, something that Jay has been pioneering on, to also include injunctions and orders compelling action, and extraterritorial jurisdiction. This is a tricky one. Generally, courts hold that the best forum in which to try a case is where the harm occurred, but we're seeing a number of countries carve out exceptions for violations of human rights and other international law. Three quick slides on conclusions. First of all, in terms of the findings, COVID-19 has had a significant impact on environmental rule of law, both positive and negative. I would say more negative than positive, but it's, there have been some innovations that we've seen coming out of this that are helpful. We see both recognition of environmental rights accelerating and the integration of them. There's growing attention to the specialized environmental enforcement capacity, particularly in institutions. We see critical importance of women as champions of environmental rule of law and the need to facilitate, empower, and protect that role. Technological revolution driving environmental rule of law in many areas, and climate change, which is not new, but it dominates this space. There's so many cases in comparison to other environmental cases. In terms of the recommendations, first is along the lines that Sue Young was mentioning, to standardize and track environmental rule of law indicators. We greatly expanded the indicators from the first report to the second report, and I'm trying to, as we carry forward, refine that set of indicators. Secondly is thinking about what does environmental rule of law look like in emergencies and disasters. There's COVID on the one hand, but then we see both in Turkey after the earthquake, and there was just massive devastation, widespread, and in Ukraine, where the war has been causing significant damage. How do you recover? Do you have to do an environmental impact assessment for everything you rebuild? You can't. There isn't capacity. So do you ignore the law? Or is there some way to comply with the spirit of the law, but maybe adapting it? So there's a need to think through, what does environmental rule of law look like in situations of emergencies and disasters? There's further needs to integrate social justice into environmental institutions and establishing a technology policy interface. In terms of areas for further research, gender comes up frequently throughout the report, and there are expanding ideas around gender. What is gender in terms of non-binary options, but also gender is often conceptualized as an issue of protection. And we need to protect women from gender-based violence, from discrimination. There's an increasing body of evidence, though, that when you include women, the outcomes are more successful, they're more sustainable, and thinking through not just gender as a non-discrimination issue, but how do we achieve better results by addressing gender squarely? Environmental rule of law in areas beyond national jurisdiction. This is an interesting question since we're focusing on national jurisdictions, but we're seeing, we have a new agreement, biodiversity beyond national jurisdiction, BBNJ. There, seems like everybody is sending their mission to the moon and to deep seabed and poles. And the question is, there are a lot of resources. Some of them are minerals that are necessary for the green revolution. Others have oil, which still is valuable. How do we advance environmental rule of law in these areas? There are questions not only about the how do we use the environmental technologies, but how do we address some of the dangers around privacy, for example? How do we think about environmental rule of law in fragile and conflict-affected settings where the rule of law is tenuous at best? And I mean, is this something that, that using environment as a thin edge of the wedge to build rule of law, or is there a kind of a sequenced approach? And finally, what's the role of civil disobedience in environmental rule of law? How do we think about that? And I'll stop there and turn it over to Lydia for the cross-cutting themes.
Excellent. Good. Thank you, Carl. Thank you, Soo-Young and Patricia. When we were developing this report, we had several goals. We wanted to capture the current status. We wanted to look at future directions and trends, but we also wanted to reflect aspects of the current moment that are impacting environmental rule of law, so that in the future, after the third environmental rule of law report, after the fourth, after the fifth, when people go back and look at this one, they can see how we dealt with the problems that were confronting our particular time, so that this analysis remains relevant. And we identified 4 themes that we thought particularly capture this moment in time in relation to environmental rule of law. This is not comprehensive. There are many other aspects of this time that we could have chosen, but we selected these 4. 1, the impact of the COVID-19 pandemic. 2, the growing use of technology in people's lives and in environmental enforcement and law enforcement and governance more broadly. 3, the connection between social justice and environmental justice and environmental issues. And 4th, climate change. And we went back and forth on that one because we thought, oh, do we really want to pull out climate change as the issue among the many, many environmental threats that we're facing now? But given the unprecedented global reaction to climate change, the global awareness of climate change, and the amount of impact that this climate change awareness has had on development of law, on education, on civic engagement, we thought that it was worth highlighting, not as the most important problem we're facing, though some may argue that it is, but as one problem that really characterizes our time. We wrote this report during lockdown. Predominantly, COVID-19 was a feature of all of our lives. It had an unprecedented social and economic impact. That led to some direct environmental impacts, some of them positive. There's evidence that the economic impacts and social behavioral changes of COVID-19 may have contributed to a global decrease in greenhouse gas emissions and a global decrease in ocean noise. There's also evidence it may have contributed to an increase in plastic pollution, including use of single-use medical supplies. And there's some evidence that the economic downturn associated with COVID-19, particularly in affecting low-income and vulnerable communities, may have increased pressure on natural resources and highlighted our dependence on natural resources for fundamental survival. Above all, COVID-19 was a health catastrophe. Many people lost their lives. The world is still dealing with the health impacts of COVID-19. These health impacts connect to environmental impacts in a way that disproportionately affected certain communities. Communities that were already affected by environmental harms, by pollution and environmental degradation, they were more likely to already have health issues that made COVID-19 much worse for them. I remember in the beginning of the pandemic, we were all talking about comorbidities. And there was almost maybe COVID-19 isn't that bad if you don't already have one of these health problems. Well, the fact is these health problems were much more prevalent among certain communities that were already affected by environmental harms. As Soo-Young mentioned and Carl mentioned, in response to COVID, some countries adopted new laws designed to protect the environment, both in the medical waste space and in the illegal wildlife trade space. Others relaxed regulations and enforcement, and in some cases, this was a practical decision. In the time of necessary social distancing, it wasn't practical to send monitors, to send enforcement agents in to check what was happening. It wasn't seen as equitable, as right to stringently enforce environmental regulations that might have had a health impact. Sometimes this happened in the same country. As Carl mentioned, COVID-19 may have contributed to limited opportunities for civic engagement and access to justice. Public consultations, in-person public consultations, were canceled broadly around the world. Court hearings were postponed, were deferred. This reduced, in many ways, the ability of people to bring cases and the ability of civil society organizations and the public to engage in environmental decision-making. However, there was also some innovation in getting around this, and those innovations, we may be able to continue using them. We may be able to use that as we go forward, particularly innovations in virtual engagement, judicial case management, and the digitization of environmental legal processes. COVID-19 was a huge catastrophe. It was a health catastrophe. It was an environmental catastrophe. So it feels flippant to talk about opportunities coming out of such a tragedy. However, as we are building back, as we do have to build back, there are certain ways we can take advantage of that time to build more inclusive and accessible systems and processes, bringing along the innovations that were developed out of necessity during the pandemic times. Another message was really brought home by the COVID-19 pandemic is that an investment in environmental rule of law is an investment in health. There was a lot of debate about whether this pandemic was related to illegal wildlife trade. Was this a result of, illegal gray markets for wildlife? What we do know beyond doubt is that there is a link between environmental degradation and human health, that environmental degradation can lead to an increase in zoonotic diseases. It can lead to health impacts that make other health problems worse. So whether or not we come to a conclusion on the exact origins of the COVID-19 pandemic, we know that environmental degradation made it worse. And we know that addressing environmental degradation, including through improving environmental rule of law, is one way that we can help support human health going forward. The second cross-cutting theme is the increasing use of technology. Technology is being used in monitoring and enforcement in new ways and potentially very exciting ways. Earth observation technology and satellite imagery is being used to detect illegal activity, from deforestation to illegal mining activity to illegal fishing. Processing this enormous amount of data can draw on machine learning and AI and these new technologies that can let us in real time identify and flag illegal activities in a way that we weren't able to this extent previously. In some cases, this draws on citizen engagement, both citizen involvement in monitoring and enforcement through technologies that let individuals, that let members of the public report on potential illegal activities or potential unsustainable activities, such as excessive idling of vehicles. Technology has also facilitated citizen engagement through virtual engagement and judicial proceedings, expanding use of social media in organizing. And I feel like we've been saying this since the invention of social media, which I am old enough to remember. But we're seeing it more and more. We're seeing the more and more the prevalence and the power of social media in citizen engagement in environmental law issues. And we're seeing the use of technology in drafting and interpreting law. And we developed this report really before ChatGPT exploded onto the scene, but I think the conclusions we came to have only been reaffirmed and highlighted by the new technology. I know my students, even some of my colleagues, are using artificial intelligence in legal research and in legal interpretation, and I expect we're going to see more of that. And that might be a good thing. It might help us become better environmental lawyers, but there are also things to look out for in the increasing use of technology and environmental rule of law. One is this common saying in computing: garbage in, garbage out. If the data and the information going into the technology is garbage, if it contains the biases, including the racial biases and social biases that many humans have, those biases may be entrenched in that technology. This raises a danger in monitoring and enforcement. If we're using crowdsourced enforcement, if we're allowing people to report on their neighbors for idling their vehicles, there is a danger that racial bias and other social biases will be introduced into that. There's a danger of reliance on incorrect or misleading information that an algorithm or a machine learning system that is trained on a certain type of information may be more likely to flag certain violations over others. There are privacy and rights concerns, as always, with using observation technology. Beyond satellite observation, drone observation, use of radar, heat sensing, other increasingly potentially invasive forms of monitoring raise significant privacy and rights concerns. There's a growing digital divide. We can talk about how internet access and digitization of environmental processes in one sense makes them more inclusive. It allows people who can't physically get to the hearing or to the public consultation to participate, but only if they have an adequate internet connection, only if they have the capacity to engage digitally. And that's not true around the world. It's not true of every community, even in the United States. And we're seeing this digital divide growing even as our reliance on internet technology and other digital technology increases. And finally, there is a question of digital security and the potential for malicious use. At the time that we were dealing with the global pandemic, the social justice issues around racial discrimination and discriminatory law enforcement in the United States and around the world became so salient and so prevalent that even during a pandemic, thousands, millions probably took to the streets to protest racial injustice and social injustice. The phrase "I can't breathe" is bone-chilling, but it also represents a link between the many humans, particularly Black men, who were affected by police violence, and the health impacts that have disproportionately affected racial minorities and disadvantaged social groups, including air pollution. I've talked about the cumulative impacts of health, environmental health hazards. A term for this is sacrifice zones. Sacrifice zones are important to confront because they encompass the idea that we can be making decisions that we don't think are biased. We're citing environmental hazards in what seems to be the best place to cite them. We're making environmental decisions in a way that we think is going to minimize overall impact. However, the totality of those decisions can result in certain areas getting a disproportionate brunt of environmental harms. Social and racial justice movements around the world have recognized this. Black Lives Matter in the United States, equivalent organizations around the world made the connection between racial justice and social justice and environmental justice, including climate justice. In the international space, there's been increasing recognition of the connection between environmental rights and human rights. We've talked about the rights of environmental defenders. Also, this connection between race and other disadvantaged social groups and environmental enforcement has become too salient to ignore. At the same time, as Carl said, we're moving away from a conception of disadvantaged communities, disadvantaged genders, people facing oppression as victims, because they are doing so much as leaders at the forefront of civic engagement and lawmaking. Involving different perspectives and diverse groups in environmental decision-making results in better environmental decisions. This is true across social decision-making studies. So a conscious focus on diversity and inclusion in institutions potentially leads to better environmental decision-making. We're also seeing an amazing upswell of recognition of women, Indigenous people, racial minorities, and youth as environmental champions. The final cross-cutting theme is climate change. And as I said, we went back and forth on this one, and I was opposed to it at the beginning, including this as a cross-cutting theme. Not because I don't think climate change is important, but because I thought, like, why would we draw out this environmental issue of all the environmental issues? And climate change is not new, and it's not going away. So how do we say climate change is representative of this moment in time? And I was convinced, as I usually am, by the data, by the sheer numbers of people and the public who are aware of and concerned about climate change. The amount of civic engagement we've had on climate issues in the past few years has been unprecedented. At least 34 countries declared environmental emergencies. At the time of writing the report, that number has gone up. At that time, there were over 2,300 climate change cases filed in over 55 countries that we know of. Almost certainly, there have been many more since then, almost certainly in countries that we didn't include in this study because the data was not available. Looking at these cases, we can see what's been called a rights-based turn in climate litigation, an increasing recognition and focus on human rights as an issue in climate cases. We've also seen a connection to future generations, intergenerational equity, and movements led by current youth. And finally, we've had a number of UN resolutions on climate change and human rights that really emphasize this connection. So I think I will stop there so we have time for discussion.
Thank you very much, Lydia. We have a few questions in the Q&A. I don't know if anybody in the room has questions. We do have microphones, so for the people online. Madison?
Well, you want me to go? You want me to
Please,
be
please.
first? I was volunteered to be first. First of all, this has been fascinating. I read and wrote a blog on the original report, and the expansion of the agenda and the number of problems has been extraordinary. And I also was totally not tuned into the impact that COVID has had during this about 5-year period. And because the one thing I'm gonna raise is a sort of minor complaint, and I think I can answer on my own question. And that is, I don't think I heard the word compliance in this entire presentation. And you know, the part of the thrust of the first report was, we got these great laws all over the world, everybody's got wonderful environmental laws, and you've got lots of new ideas for more. But there was very little follow-up, particularly by government agencies who were supposed to be inspecting or issuing orders or reviewing monitoring reports, et cetera. And I heard nothing about whether any of that has changed in a positive direction, and whether the people, institutions, business, government, individuals who are supposed to do things are any more likely to be compelled to do them than they were 5 years ago. And my answer to myself might be, well, with COVID, I mean, you obviously couldn't be out inspecting factories or following this or doing that. And so there are reasons for that. But I do find it somewhat startling to hear nothing about the public agency follow through, other than the fact that you say there's been a lot of litigation, which it sounds like it's been mostly from private people. So I wish you'd just comment on whether that conclusion from the first report, maybe I just misread it, but I was expecting to hear more about whether we had strengthened the ability to actually achieve the objectives and the requirements of environmental laws.
Thank you. Anybody else in the room? Yes, Justice.
Thank you so very much. I wish to appreciate the efforts of all those who work on the second report, Professor Camila, Motea, and the rest. I wish to thank Eddie equally for this opportunity given to us to be part of the launch. I'm just concerned with two issues on the recommendation on how environmental rule of law from the report could help influence national policy reforms such that evaluation of environmental rule of law should equally reflect evaluation of the level of implementation at the national level, because we think globally, but we act nationally.
Or fail to act.
And the second issue is with respect to capacity building to enhance compliance and enforcement, which one of the panelists referred to as implementation, because there is need, especially at the level of the global south, to enhance human and material capacity building, including issues of technology transfer for effectiveness with respect to environmental rule of law. So I was looking forward that this should equally be reflected in the recommendation and how this will be achieved, such that the third report will be a survey of what an assessment of what has been implemented so far with the requisite capacity. And my last concern is with, at the national global level, what contributions could be done in order to have global instruments that reflect the concerns of the stakeholders and the majority of the people, and equally address the specific issues that they are meant to be, like having a plastic treaty that is not only ambitious, but will be implemented. Because having a law is one thing, having a law that will be implemented is what we, how we assess environmental rule of law.
Thank you. And one more, I think you had a question.
I can learn from these calls. It looks like we have quite a list now.
Okay. So we have a few online. I'd like to just quickly read them out and then we go around the panel. I think that'll wrap up our time. So the third question, or the next question is, who, maybe Soo Young, if you could take this, who filled out the surveys? And did the UN do any follow-up or confirmation checks on the answers provided? Next question was, how does the movement called the Rights of Nature fit into this? Maybe Lydia, if you could address that. And then, other than loser pays rules, where do the panelists see backtracking in environmental rule of law, either in particular regions or in substantive environmental areas? And the final question from the online was, who thinks through and creates environmental law? So, Soo Young, would you like to start? And you could address some of the other questions too, not just the one that I flagged for you.
Okay, no problem. Thanks, Carl, and thanks for the questions. So on the first question on the survey, so these questions that we circulated, so it was done by the lawyers in the country. Each country we actually had the really privilege of having all the lawyers working in each country with the help of Bank Center and the Whiting case, as I mentioned in the beginning. So they were filling out the surveys because they know the national law. And these questions were not very subjective, as you will see in the report. We have the list of questions that we developed in the report. So as you review the law at the national level, you'll be actually will be able to answer yes or no. For instance, whether there's a law that explicitly protects environmental defenders. So it was the lawyers at the national level, but we also did a follow-up second, and also we did a verification by ourselves, but also by the Bank Center. So that has gone through 2-3 times of verification, and also a few discussions like whether we should do this as yes or no. So this is how we've the answer then that came up with this data set that we have in the report. And if I could just tackle on the second question of rights of nature. So I think Carl mentioned the rights of nature, how in the report, how that is actually mentioned in the report. There's a trend that is coming up. There's number is small, but we see the definite trend that is that a lot of countries at the national level or subnational level, they are moving towards recognizing or moving towards being interested in this. So this is an issue actually the UNEP is also looking at separately in relation to environmental rule of law, but also as a different subject, as an independent subject matter. So we've had an expert consultation last year in September on this issue, and we are currently developing an explainer on rights of nature, because we identified during the consultation and doing our research that rights of nature is fascinating topic, but it's not very clear to a lot of people. And it is not clear because at the national level, recognition varies from one country to another in the level of recognition and also the implementation and what they recognize as part of nature as well. So this is upcoming, and hopefully you will stay tuned for this one. And another on rights of nature, also other emerging environmental law issues. We also hope to address this more in our third environmental rule of law report. So we'll try to also come up with other emerging issues, such as space or rights of nature, and some other issues with a more highlight of this. Back to you, Carl.
Thank you, Soo Young. Patricia, I don't know if you would like to jump in on any of these questions.
I think the questions have been answered well, and what I'm looking at is going forward. What is it that we will do to deepen some of this? I saw that somebody had asked for the first report, and I think we can provide a link to that.
Yes, I've received confirmation.
Okay.
Lydia?
Yeah.
Compliance, seriously. Com- Compliance, no, seriously, I agree. So compliance is so hard to measure in a way that is fair and objective and rigorous to some extent. In the report itself, where we deal with compliance, we approached it in a couple of ways, none of which is perfect. And this is one of the issues that we as a global community are going to keep working on going forward. How do we measure compliance? How do we track compliance as an environmental rule of law indicator? The ways that we looked at it were, one, through case studies and examples. And you'll see throughout the report examples of public agencies, of institutions, of the impact of civic engagement, the influence of civic engagement, of the realization and recognition of rights in practice beyond just on paper, of effective and fair judicial processes. We were able to capture those through case studies. As far as the indicators, most of the indicators are looking at, because this is what it was feasible for us to collect, legal frameworks that exist, but also the enabling factors for compliance. So the existence of certain types of institutions that can promote compliance, the existence of legal mechanisms that can support compliance. But yes, no, absolutely. This is a project that we and the world are working on. How can we, moving forward, develop indicators of compliance that can be evaluated in a way that is rigorous and objective and realistic? How can environmental rule of law influence national policy reforms? How could it affect implementation at the national level? Again, I think a lot of the case studies that we were able to collect through this report and the work that we need to continue doing of collecting this information from around the world can help inform practices in other countries. So, for example, in the examples of responses to the COVID-19 pandemic, we found some interesting, innovative examples of use of technology and almost the reverse of technology, use of techniques from a previous age, such as mobile courts. Sorry? Such as the use of mobile courts that would physically go like riding the circuits to communities that were not able to access judicial resources during the emergency time. These kinds of innovations, I think, can be very interesting if we can share them, if we can share this knowledge with other jurisdictions to help improve implementation. And then, yes. Absolutely, as we negotiate international agreements, regional agreements, as we think about implementation of law at all levels, we need to consider the implementability, the workability of legal frameworks. That is clearly going to involve capacity building. Rights of nature, I think even since we finalized the drafting of the report, the rights of nature movement has grown in visibility and in power. Rights of nature, there's almost two things going on with rights of nature, which I find equally fascinating. One is kind of the practical legal aspect of recognizing legal personhood of non-human entities, whether that is a river system or an individual hippo. This aspect of rights of nature is about making our legal system work better in the way that recognizing legal personhood of a ship or of property historically was done not because we thought that ships or corporations, well, historically, didn't think that ships or corporations had any special entitlement to rights, but because granting them legal personhood made our judicial system work better. It was easier for the legal system. On the other side of the rights of nature movement, we have almost a moral or an ethical movement saying, yes, legal personhood is a really cool and interesting and important legal tool, but also river systems and mountains and the earth as a whole, nature as a whole, it should have rights. We should recognize the rights of the natural systems that are non-human in our human legal system. That will get us what we want in terms of environmental goals, but it's also a moral imperative or an ethical imperative. And this branch of rights of nature, I think has roots in both Western legal systems, but also in non-Western legal systems, in customary law, in the laws of indigenous peoples around the world, even in the laws of some religions around the world. And I think I hope that we get to work on this more in the next report, because I find this development of rights of nature really fascinating and really impactful. I think I will leave the rest for you, Carl.
Thanks. On the question of backtracking, I would also say that the loser pays principle isn't backtracking. This has been a problem the whole time. It's just that we had the evidence to be able to speak to it. And so backtracking implies that we made all this progress and then we've eroded. This has been a challenge all along. I think that there are kind of two areas that I would say we saw backtracking in. Well, I will say we saw it in one area, and then I will speak for myself on the other one. So we saw backtracking with COVID. Some of it was practical. You can't send, there were difficulties in sending out inspectors, things like that. We also heard from a number of people as we were developing the report that COVID was a pretext, that there were governments that wanted to roll back environmental protections, and they used COVID as a pretext for rolling it back. So I think I could say that we saw that. The other thing, I just want to be very clear. I'm not speaking for the report. I'm not speaking for UNEP, but I saw a number of instances where we see a rise in nationalism and populism that has led to a weakening of institutions, a weakening of accountability, a weakening of rule of law. And I just want to be clear about this, because UN agencies have member states, and member states don't like being called out on these things. So I'm not speaking for the report, I'm not speaking for UNEP on this, but we have seen a number of instances where new governments come in and that has weakened funding and mandates and appointment of persons who are known to want to eviscerate the institutions that they're now in charge of. So that sort of, we saw backtracking in a number of countries in recent years in that. And given the politics, I don't know that that's necessarily going to change globally, that we're still in this period of nationalism and populism in a lot of countries, including some major countries. And I'd like to close coming back to Leslie's comment about compliance. And it's for me, it's the same question. These reports, we use mixed methods. At core, we're trying to take a global survey of where do things stand. And the question is, sorry, is this close enough? Oh, okay. The question is, how do we know the legal or kind of the statistical basis for this? And it's really hard. You can track inputs, Are there laws? Are there environmental prosecutors? Are there mandates? You could track contextual factors. It's really hard to track compliance rates. It's hard to track, the data on a lot of these things does not exist generally, let alone globally. And so I would invite, as we think through where do we go from here, what would be an appropriate indicator of compliance? And compliance with which provision? The whole law, generally, but kind of what is or what are appropriate indicators, and where do we get the data? But I think that one of the really exciting things about this is the evidence base. When we started the first global report, there are questions about, so how many countries have framework environmental laws? And the UN Environment Program, the leading global institution on environment and environmental law, didn't know. We had to generate that. And we did that, we did other things. And in the process, we are building the evidence base to say, where are we? Where have we been? Where are we going? And I think we're still fairly early in that arc, but it's really exciting because, lawyers are not generally taught to track these things. We're taught, it's like, here's the evidence, good, bad, or missing. Here's the evidence you have, and you make do with what you have. We're not really taught to generate evidence of the effectiveness of policy approaches. And I think that's one of the really exciting things about this endeavor. And so I'll wind up there. I want to thank the speakers for sharing their expertise, and thank the Associates Program for convening this and making it all happen. Madison, over to you.
Thank you so much. Just want to give a quick thank you to all of our speakers. Thank you, Carl, Lydia, Patricia, and Sue Young. We so appreciate you taking the time to join us today. For our audience, please join us in the future to explore these issues even more. So every Wednesday through the first Monday of every month through July, we'll be exploring more of these topics. Sarah's put the information in the chat for the virtual folks if you'd like to register for future sessions. They'll all also be recorded, so if you can't make it to one, you can watch the recordings later. Thank you all and have a great day.